Hello and welcome back, your faces, to another live stream here on this channel. It's not a live stream, as you can see, because it's not going out live, but I did record it as a live stream because we got so much information to go over. It is just incredible to see. Excuse me. So what we're going to do, we're going to shoot on over to it and actually see what's happening. So this is what we got, ladies and gentlemen. Yesterday, our good and amazing friend, Nick Wallace, he put out a little Christmas treat, and let's just say it was unbelievable. So this is what we're going to do. We're going to go through it all because, as you can see, when I scroll down here, there's just so many tweets about this from Nick himself. And what it is, it's actually Johnny Depp's appeal against the UK courts. And let's just say it is so sweet and so amazing. It's crazy. So we're going to start straight away. So Nick Wallace, he put this out 16 hours ago and he went on for like 3 hours. Attention followers of the Johnny Depp vs NGN and RUIN legal battle. An early Christmas present for you. I think this is a world exclusive. Mr. Depp's representatives have filed 2 documents to the Court of Appeal at the Royal Court of Justice, London, England, seeking leave to appeal Mr. Justice Nichol's High Court ruling. That ruling, handed down on the 2nd of November this year, found the Sun newspaper's claim that Johnny Depp was this to be substantially true. At the time, Mr. Depp's legal representatives described this decision as perverse and sought leave to appeal. That request was denied by the High Court, which was done by Mr. Justice Nichol. So Mr. Depp has gone direct to the Court of Appeal. He is seeking permission to appeal a judgment. If he is successful, he says he will ask the Court of Appeal to set aside the judgment and order a retrial. That is just amazing to see, because when you have a retrial because of what exactly has happened here, because obviously, we have seen so much stuff come of this right now, and because of the people involved, everyone's going to be like, oh my god, what the hell has gone on, you know? So that's what I think is just amazing. So, so the first document is the grounds of appeal, which is 5 pages long, followed by the skeleton argument, which is 23 pages long. The following tweet thread lays out most of the paragraphs from both documents. I will make the full documents downloadable from my website, so what I'll do with that, guys, I will put the link below, so in the documentation, in the description box, so if you want to see it, you'll be able to see it by there. I've also put down the link thread for this entire thread on Twitter. It'll put you to the very top of it, and you scroll through yourself. To be clear, in the following documents, the appellant is Johnny Depp, the respondents are NGN, who own the Sun newspaper, and Dan Wooten, who wrote the original Sun newspaper piece. Ready? Here it goes. So, we're going to start off. In the Court of Appeal civil decision on appeal from the High Court of Justice Queen's Bench division between John Christopher Depp and NGN. Don't worry, it's not all in caps. Good. So, nature of the appeal. The appellant seeks permission to appeal, and if granted, to set aside a decision of Mr. Justice Nichol, the trial judge, finding that the respondents had proved that the defamatory allegations they published were substantially true. It is recognised that the appellate court will be slow to set aside a trial judgment with findings of fact because of the greater ability which the trial judge usually has to assess the witnesses, whose evidence they are based on. In this case, the Court of Appeal should do so because the trial judge failed to examine the evidence and the arguments with the care that the parties were entitled to, expect and which a proper resolution of the issues demanded. The judgment is plainly wrong, and the consequential decision in favour of the respondents is manifestly unsafe, because the trial judge's findings were not conclusions based on or supported by a carefully weighed and reasoned analysis of the evidence or the credibility of the various witnesses, but rather bare assertions without any real explanation for how he reached these serious findings in the face of conflicting accounts of events. And B, He uncritically accepted at the outset that the complainant must have been correct in her allegations and, having done so, discounted or ignored any evidence to the contrary, despite the fact that it undermined her credibility and the account she had given. Which is very true, because we have seen all the evidence, which now is just fantastic, because so many people are coming out and saying, we've listened to the evidence, we've seen the evidence. How can anyone say that's not real, you know? Despite its length, the judgment lacks both analysis and reasoning for the trials. Oh, we have that one? No, we haven't. We haven't had that one. Sorry, guys. I'm a little bit all over the place because it's Christmas Eve as well, you know? And I'm doing this for you lovely people. Despite its length, the judgment lacks both analysis and reasoning for the trial judge's decision to exclude matters which are damaging to or inconsistent with the evidence of the witness on whose veracity or reliability the respondent's entire case depended, namely AH. Or as to why he made the findings of fact he did as to what he said happened. In view of the unreasoned, inconsistent, and unsustainable findings of fact in this judgment, the appellant did not receive a fair trial in protection of his rights in accordance with both Article 6 and Article 8 of the European Convention on Human Rights, where allegations of serial criminal conduct are determined by a single judge. The importance of an effective appeal process is far greater. Further, these findings have been reached in a judgment that has been very widely publicised, which is not only devastating to the appellant, but also has wider repercussions for alleged victims or those who are wrongly accused of DV. It is the result of a high-profile libel trial, one which until relatively recently would ordinarily have been determined by a jury, which is very true, where the evidence and argument was closely followed and examined by the public as it proceeded. This is therefore a paradigm example of a case where there are additionally compelling grounds for the judgment to be reviewed on appeal in any event, but particularly given the weight of reasons which render the findings that the trial judge reached plainly wrong or unsafe. Grounds of appeal. The judgment is plainly wrong and or the trial judge failed to examine the evidence and the arguments with the care that the parties were entitled to expect and which a proper resolution of the issues demanded for the following reasons, any of which would be sufficient to justify setting aside a decision in favour of the respondents, but which taken cumulatively render the judgment manifestly unsafe. The trial judge's finding of fact on issues of central importance amounted to bare assertions rather than reasoned decisions, following upon a carefully weighed up and reasoned analysis of the evidence given by both sides. As a result, there is no proper explanation for how the trial judge reached these serious findings in the face of conflicting accounts of events. He failed to give reasons to expel... excuse me, my mouth's all over the place today. Giggity. As a result, there is no longer proper explanation for how the trial judge reached these serious findings in the face of conflicting events or accounts. He failed to give reasons to explain what evidence he found to be sufficiently cogent so as to satisfy the required standard of proof in light of the criminal nature of the allegations complained of, which he never did. We were seeing that he just went, right, I'm going to throw this one out, this one out, this one out. Oh no, but that one's true. Because if you remember, out of 14 instances, he only threw out 2. But number 1, he actually threw it out and said he didn't believe it. But then he was like, oh no, you know what though? No, I'm going to keep that, which is stupid. Then we got number 2. The trial judge failed to test the oral evidence given by Miss Heard against contemporaneous documentary evidence or the evidence from numerous independent and professional witnesses. Further, he reached conclusions on this evidence which were outside the bounds of a reasonable finding, particularly given the implausibility of many aspects of her account, which if treated or followed through consistently would have critically undermined the veracity of her account of the physical that she claimed to have been subjected to or the physical injuries she had allegedly suffered, none of which were supported by medical evidence. The trial judge failed to examine or assess properly the credibility of her or the other principal witnesses on behalf of the respondents, including by ignoring contradictory or relative evidence relied upon by the appellant that undermined such credibility or the account which was given. It seems that having uncritically accepted at the outset that Miss Heard must have been correct in her allegations, the trial judge discounted evidence to the contrary, even attributing to the evidence which he did not give in order to cater for the obvious weakness or improbabilities in her evidence. The trial judge failed to consider or otherwise address his mind to the impact of finding that one of these, alleged by her in the confidential judgment, did not happen. Number 5. There's so much, guys. I do apologise. This will probably be going on for a little bit longer than we normally do, because obviously I won't be doing this condensed because you can't condense this. It's literally just all this. Hence why I'm doing it like a live stream. But it's a private live stream that's going out to you lot later. If that makes any sense. I don't know, guys. So, number 5. Given the seriousness of the allegations involved and the fundamental importance of assessing the credibility of the starkly opposed accounts given by the appellant and his numerous witnesses, several of whom were independent of him, which they were, on the one hand, and Miss Heard and her close friends on the other hand, it was incumbent to the trial judge to closely examine and provide a proper assessment of the principal grounds on which Miss Heard's credibility was challenged, or at least address them. He did neither. Yeah, Judge Nichol just needs to go now. And obviously next year he is retiring. So with that, with all of this going forward as well, I'm pretty sure he's going to take early retirement. You know, even earlier than what he was meant to do in May. Credibility was challenged. Yep, we had that one there. Number 6. Conversely, the trial judge made no findings that the appellant or other witnesses were dishonest, as would be inevitable given his findings of fact. Despite this obvious and fundamental flaw with the judgment, the trial judge failed to give any real reasons as to why he did not accept their sworn testimony. The trial judge earned in law applying S4 of the Civil Evidence Act 1995 to the evidence of an LA police officer who had attended Miss Heard's home after one of the alleged incidents of DV, and whose subsequent deposition in legal proceedings in the United States, which Johnny Depp did rely upon. The respondents obtained an order pursuant to CPR requiring the officer to be cross-examined, and the officer attended court, via video link, for that purpose. The respondents made a deliberate decision not to cross-examine him. The officer's evidence was thereby unchallenged, and the Civil Evidence Act had no role to play. Further, the evidence of this officer, which despite critically undermining Miss Heard's veracity went unchallenged by the respondents, was discounted by the trial judge, as was the evidence of his colleague, an officer experienced in DA cases. Which, straight away, as we all know with that, the judge literally... Oh, let's go over there, man. The judge literally just said, yeah, we don't really care about the police. We don't really care what the police say, which is absolutely diabolical, because it's the police. You know, how can you say, oh, I'm not going to believe the police, I don't think it's right, which is absolutely just crazy. Because how can you say, oh, you know what? Yeah, I don't actually believe the police. We're not going to leave them in there. We're not going to take in their testimony, which is just crazy. So let's get back to it. So, reasons for granting permission. In the premises, it is contended that the appellant has, at least, a reasonable prospect of success. In accordance with the test for granting permission to appeal, the appellant will detail in his skeleton argument a number of examples which demonstrate the reasons outlined above. However, given the limits imposed by the practice direction to the CPR, Part 52, these will be merely examples as opposed to an exhaustive list of the ways in which the judgment is seriously flawed, and the findings of fact upon which it is based are manifestly unsafe or perverse. Whew, there's a lot still going, guys. I do apologise. It's going to be a little bit of a long video live stream, as we like to call them at the moment. So, we had that one there, perverse. Right, okay. The example which demonstrates a reason outlined above will be detailed in the appellant's skeleton argument, which is below. It'll be placed before the trial judge. Further, and in any event, there are Excuse me, I'm getting a bit tongue-tied. Further, and in any event, there are other compelling reasons for permission to appeal to be granted. This was a very public judgment, reached by a single judge, making devastating findings of extremely serious offences having been committed, and where this had a wider range implications for the public at large, particularly victims, or those wrongly accused of alleged DA. It is important that in such circumstances, and especially where the flaws in this judgment are so many and so fundamentally as to warrant a proper review, that there is an effective appeal process. Ends. Phew. That one by there was actually just the top part of it, and is absolutely crazy to see, because exactly what the judge, well, not the judge, sorry, but what the appeal says is very true. What we've all been talking about. You know, we've all said, any people coming forward, any victim, they're going to look at this and think, how am I going to win this? How is this going to benefit me? Because it can't, you know? Because this is going to just basically stop people thinking, yeah, I'm not going to win. Even though I am the victim, I'm not going to win. Which is absolutely disgusting. And as you can see by there, Nick does say that, my friends, was just the hors d'oeuvres. The skeleton argument will follow soon. First, a short commercial break. My work on securing and publishing these documents is entirely crowd-funded. Which, guys, I will put Nick's tip jar down below as well, if you would like to donate to him, because I already have, and it's absolutely amazing that this guy deserves everything he's going to get, because he has done such a great job on this. So now he does carry on. He goes about the skeleton argument. And it does go on even further, guys, as you can see, like we just opened it up. So, okay. Appellant's skeleton argument, 21st of December 2020. Application for permissions to appeal. References in this skeleton argument to excuse me, I'm getting muddled up like anything here now. I do apologise, guys. To paragraphs of the judgment of Mr. Justice Nichol. Read that here. So we got that one by here, guys, which we're going to open up in a new link. And as you can see, this is what we got. It is so long, it is absolutely crazy, as you can see. I will put this below this entire link for you guys, because it is just such a good read, and we're not going to have enough time to do all of this, because I'm just going to be going down to where we actually stop on the last one, because I do need to get a few things done. As I said, it is Christmas Eve, so this is going to be the last part of it all now, guys. So I do not have access to the supplementary bundle. Apologies. Also, when there are two names followed by a date. So we got these here. Okay, here we go. Introduction. The appellant seeks permission to appeal the decision of Mr. Justice Nichol on the grounds that his judgment reveals a fact-finding exercise which was seriously flawed. While the Court of Appeals is understandably slow to set aside a judgment on facts because of the ability of the trial judge to assess the witnesses, that caution cannot apply where, as here, the judge failed to perform the tasks appropriately. The judge conducted no analysis of the evidence of the alleged or injuries which the appellant is said to have inflicted, or the credibility of the witness. Good with it. Further, the judge failed to explain his reasons for his findings, which are simply asserted as opposed to reasoned by reference to the conflicting evidence, the documents, the witness statements, and oral testimony. This was a liable trial in which the respondents needed to prove that the appellant was guilty of beating his former wife on a number of occasions, causing her significant injuries and leading her to fear for her life. Upon initial accusing of the appellant of this in 2016, AH relied on 3 incidents to obtain a temporary restraining order: December 2015, April 2016, and May 2016. By the time the appellant brought his claim against the respondents, AH was advancing 14 separate incidents over a 3-year period. By the end of the trial, an undefined number of further ones were alleged. Despite this, and the wealth of conflicting evidence presented, the judge failed to examine the competing accounts of each incident or to explain whether he found them proved, and if so, on what basis. The same failings applies to the inconsistent accounts given by AH, who was the sole witness for the respondents in relation to all bar one of these incidents, of the injury she had allegedly suffered. A table of the 15 incidents, the alleged incidents and injuries and the relevant passages in the judgment is attached as scheduled, so we got down by there. Should have analysed the extent to which AH's evidence undermined her credibility in relation to her allegations of all of this. Despite the central importance of this issue, as both parties emphasised throughout the trial, the judge carried no assessment of AH's credibility. Excuse me. The judge accepted at the outset that AH must have been correct in her allegations, and then discounted any evidence to the contrary, even attributing to Miss Head evidence which she did not give, and thereby bolstering her evidence. The improvement of her evidence on occasion is a compelling reason why his findings, are unsafe. You know, I do say that because we don't know what happened behind closed doors. Sorry about that joke again. Sorry, Judith. I didn't mean to say that. I got told off by Judith the other day for doing a sex joke. I'm sorry. So, the judge took little or no account of the striking examples of AH's willingness to lie or commit wrongdoing, which should have reflected upon her reliability as a witness. Even in the face of documentary evidence, which is very, very true, such as an email to a personal assistant asking if there was a vet who could be greased in order to procure a slightly altered health doc to get them into Australia, where she committed perjury. The judge failed to examine the starkly opposing accounts given for each incident by the appellant and other witnesses. The evidence from 19 witnesses, many of whom were independent, were either dismissed or ignored. Although none were found to have lied, the judge accepted AH's evidence uncritically, but made no findings that the appellant and these witnesses had lied. It is inexplicable that the judge made no adverse findings on the appellant's credibility, given the fact that he accepted AH's version of events, which conflicted sharply with both his evidence and the contemporaneous documents. It's absolutely crazy, guys, I'm telling you. Everything that this guy is doing and everything that has gone forward, this just shows is absolutely crazy now. It was accepted by the appellant that he drank heavily at times and done this, as did AH, which he did, but he was unequivocal that he had never attacked her, or any other woman in his life. There is no proper explanation or reasoning in the judgment as to how the appellant's admitted use of was connected to all of this. The judge's conspicuous failure to analysis the evidence and the arguments for each incident with the care that the parties were entitled to expect, and which a proper resolution of the issues demanded justifies. This court's intervening in a decision, notwithstanding its general reluctance to disturb the findings of a trial judge. This application is not premised solely on the fact that the judge reached conclusions on the evidence that were outside the bounds of a reasonable finding. The appellant's case is that the judge failed properly to analysis the evidence or to explain his reasoning. The Court of Appeal is not asked to substitute its own decision, but rather to set aside the judgment and order a new trial. In view of the unreasoned findings of fact, the appellant did not receive a fair trial in accordance with Articles 6 and 8 of the Convention. This approach the judge should have taken in cases where, as here, a judge faces irreconcilable accounts of events. The credibility of the witnesses is key, where the outcome of a case depends heavily on the oral evidence of a witness. A judge must carefully consider Jesus Christ. Literally, as you can see, I'm doing this. It's 12:30, Christmas Eve, and I haven't slept. So I do apologise, guys. The approach the judge should have taken in cases where, as here, a judge faces irreconcilable accounts of events. The credibility of the witness is key, where the outcome of a case depends on the oral evidence. A judge must carefully consider and analyse the quality of the evidence. The witness's ability to recollect events, consistency, and truthfulness are a fundamental part of the analysis which must be explained in the judgment. Contemporaneous documents are an important indicator of the truth, and the trial judge should make findings of fact based upon interferences drawn from documents and known or probable facts. Then it goes into something else by here, and as you can see there, he says sexy last tweet. No. But it does go on a little bit further, guys, but I am going to stop it by here because this has gone on now for, just coming up to 30 odd minutes. And I want to get this out to you guys. I will leave the link below for the rest of the article. It is very, very long, I will say that. And this is just fantastic to see now because this is going to ruin AH's Christmas, which I think is phenomenal. And I can't wait to see it actually ruin her. Because this is exactly what's going to happen now, guys. But guys, this is it now. I do have another video coming out later today, which was actually filmed not yesterday, the day before. And with all of this, guys, I really hope you have a fantastic Christmas. I will be back after Christmas, guys. We will probably do a live stream, possibly Monday, maybe Tuesday. If not, you will get some more videos. So if you are new to the channel, please like and subscribe, hit that notification bell, and I'll see each and every one of you soon. New to the channel, please like and subscribe, hit that notification bell, and I'll see each and every one of you soon.